Okay, 21 state attorneys general have sent a letter to the Biden administration raising concerns about the executive orders that were issued during the month of June, the Gay Pride Month. This is where all the federal agencies got in line with the Biden agenda. And this was all based upon a Supreme Court decision, Bostock versus Clayton County. Now, just to refresh your memory, this was a very limited case that had to do with employment law and transgenderism, that you could not fire or terminate someone that was, in this case, a male who dressed like a female, period. That was it. It did not go beyond that, but the Biden administration is interpreting this to go much further, not only taking it beyond Title VII, which is employment law, but now applying it to Title IX, which is the law regarding education, federal statutes regarding education. In particular, Title IX has long been, it covers women's sports, the fact that it gives women equal opportunities to go out there and play sports and be competitive. Well, they have just torpedoed that. And here's the thing. The attorneys general are making issue of this because they did not follow the law. Here to talk more about this, Meg Kilgannon, who is our senior fellow for education studies here at the Family Research Council. She's going to be back later in the program as well. But Meg, I want to take this on because this is pretty big news that almost half of the states are challenging these directives that are coming from federal agencies.
It's really great news, frankly, Tony, because when the Department of Education issued its statement, that's a gross misinterpretation of what Title IX means. Title IX refers to sex, the biological sex. It doesn't have anything to do with gender identity or sexual orientation. It's to protect women and to give women the same opportunity as men in sports and in education. So this interpretation from the department is just wrong. It's a gross overstep. So we're very grateful to the attorneys general that they have come forward and made this statement, pointing out all the flaws in the reasoning from the Department of Education. I have a letter in my office from the ACLU in Nebraska that is threatening a school board with legal action if they don't create a policy based on the erroneous interpretation of Title IX that the Department of Education has put out. And so it is wonderful that these attorneys general are putting this statement out so that the school boards that do not want to go along with this policy have a reasonable defense.
That's a really, really good point, because we've actually raised that before where, for instance, the IRS has put out this, almost always when a federal agency puts out guidance, it's very nebulous. It's there's just a lot of gray area. But it allows these other entities, for instance, under the IRS and churches, we've often seen the Freedom from Religion Foundation take this and exploit it and intimidate churches with it. The same thing happening here in education. But the attorneys general say there are two key aspects that they take issue with over the separate guidance coming both from the Department of Education and the EEOC. And here are the two issues that they take issue with that is in this technical assistance document, which is what it's called. One states that employers may not deny an employee equal access to a bathroom, locker room, or shower that corresponds to the employee's declared gender. Right. Now, of course, this we're talking now in the workplace. We're not talking about the schools. So this is one of the issues. But here's another one that's of concern, is that this states the use of a pronoun or a name that is inconsistent with the individual's gender identity could be considered harassment and open the business up to legal action by the federal government.
Right. This is, of course, just a gross overstep, right? This is just a ridiculous overreach on the part of the federal government to regulate people's speech, to regulate their behavior. And I'm very, very happy that the attorneys general are defending against that kind of attempt.
Because the court case that I made reference to earlier, the Bostock case, only dealt with the issue of employment termination for a transgender individual. It had nothing to do with showers and bathrooms.
Correct.
In fact, the court specifically did not go there.
Yes.
Also, they did not take up the issue of pronouns and make-believe names that people would say, because even the attorneys general made the issue here that there are those out there now that have made up a host of pronouns that are, quite frankly, are insane. And so will an employee, or employer rather, be liable and be potentially have legal action taken against them by the federal government if they don't play this make-believe and use these made-up pronouns?
Well, I mean, it's you could argue that it's not that hard to go by they or them as opposed to he or she, but when you are making up entire words and vocabulary, z, zer, and all of these really literally made-up pronouns, it seems a bit much.
Well, it's like a minefield,
Yes.
which they're creating. And again, the Bostock case held only that firing an employee because of the employee's sexual orientation or transgender status constitutes discrimination on the basis of sex under Title VII. They did not address Title IX at all, which is what governs education. So now the Department of Education is trying to take this Bostock case without going through, and you can speak to this because you were in the Department of Education under the Trump administration. There is a process by which a federal agency changes rules.
Correct.
They're just doing this out of nothing.
This is their favorite play, the Dear Educator or the Dear Colleague letter. This is how they do government on the left. Instead of going through the rulemaking process and hearing public comment and having the mediation that takes place at the Department of Education in the rulemaking process, they just by edict send the Dear Colleague letter out and say, this is what you can do. And we expect you to follow these rules, and they know that they have their echo chamber on the left in the form of the ACLU and all of the other groups and the media who will go along with all of this and make it very difficult for people who disagree.
Right.
And we're allowed to disagree in
now
our society.
I would say there's probably a lot in the education system like Briar Rabbit, throw me into that briar patch.
Yes.
They're happy to be thrown into that, and this gives them
They're
an
already
excuse.
doing it, right?
Yeah, right.
They're already doing it.
But to your point earlier, we thank the Lord for attorneys general who are willing to stand up and challenge this. And so, folks, I'm going to run down the states here that have attorney generals that are stepping forward. This was actually led by Slattery, Attorney General Slattery of Tennessee. We have Steve Marshall from Alabama, Alaska Attorney General Taylor. We have the Arizona Attorney General. We have the Arkansas Attorney General. We have the Georgia Attorney General, the Idaho Attorney General, Indiana's Attorney General Todd Rokita, who's been on the program many times, Derek Schmidt, Attorney General of Kansas. We have Daniel Cameron, Kentucky, Jeff Landry, my home state of Louisiana, Lynn Fitch, Mississippi, Attorney General Schmidt of Missouri. We've got Montana, Nebraska, Ohio, Oklahoma, South Carolina, South Dakota, Texas, and West Virginia. So if your Attorney General from your state is not on this letter, you should ask them why. In fact, I'll try to get this letter posted on my website so you can see it, because they actually make a really good analysis of these two technical administrative letters that were sent that, as you say, just really confuse and intimidate and allow the left to use this to beat up schools and businesses.
Exactly. And the additional point I would make is if you're sitting on a school board in any one of those states and interest groups are bullying you into adopting a transgender policy that you don't want to adopt, you know that attorney general has your back.
Right.
And you can
Yes,
absolutely
it's
and
important.
legitimately
That's
resist.
extremely
and you must.
important. That is extremely
And
important.
even if you're in a state that's not on this list, you can still point to this letter as a great reason for why the law isn't settled, the science isn't settled around this issue, and you don't have to do it right now just because the Department of Education
That
says
is
so.
a really good point on the attorneys general, because that's why George Soros and others funded a project to try to get attorneys generals elected, liberals. So if you're in the state, this is an important post to fill, especially now where you've got a federal government hostile to the Constitution, the rule of law, and your values. You can count on your attorney general, if he's good, she, to support you. All right, I want to go back to kind of where we started today's program, back to the topic of education. We were talking about the Biden administration pushing their radical transgender policy, without, basically just out of thin air, doing whatever the heck they want to do. Well, they're not alone. You would think that educators, these officials in public education, would see the handwriting on the wall, with parents filling to overflow school board meetings, angry, pulling their kids out. I mean, there's been a big decline in public education numbers. And by the way, it needs to go further. Every God-fearing American needs to get their kids out of public schools because they're being indoctrinated by the left. Well, the latest is Chicago public schools are now offering condoms to kids 10 years and older. Joining me now with more details, Meg Kilgannon, Senior Fellow for Education here at the Family Research Council. Meg, thanks for sticking around. Just when you think you've seen it all,
Right.
we get more. I mean, here comes from the murder capital of the country, Chicago, gangland country. Now, 10-year-olds being given condoms, and I'm sure they're calling the parents first to ask them about it.
I'm sure they're not actually doing that, unfortunately. This story has just been one that it's like an onion when you're peeling back the layers to try to figure out what's going on based on the media reports. The documentation that was available on the websites is not available anymore about the actual policy. So going on the news reports that I've seen, the condoms will be available to ages 10 and up. So I don't know if that means vending machines in the bathroom or you have to actually ask the school nurse for a condom. But if I were a school nurse who was asked by a 10-year-old for a condom, I don't think I would hand that child one. I would be investigating why in the world a 10-year-old is thinking that they need a condom. What is going on in the life of that child? That's just not a world that I want to live in. I reject the entire premise of this.
So this is a policy adopted by the Chicago Public School Board of Education. Schools, and I quote, must maintain a condom availability program for grades 5 and up to protect against sexually transmitted diseases, including HIV infections and unintended pregnancies. So each elementary school will be allotted 250 condoms to start with. It's kind of I guess that's a starter program. High schools will receive 1,000. I thought our kids went to school to learn how to read and write,
Yes.
and do math, and
In fifth grade, I was cross multiplying fractions, I think, and doing some new verb forms in English class. This did not involve anything like this. The issue too is such a problem when adults make policies that make adults feel like they're doing something
Right.
and completely ignore the needs of children. If there's an issue with a rise in sexually transmitted diseases in the 10 to 11 age cohort, you should not expect that a 10 or 11-year-old is going to be able to use a condom in a way that would prevent sexually transmitted diseases. That's a ridiculous premise. That is just ridiculous thinking. Children are being victimized if they are having sex at that age, and we should be, as adults, intervening on their behalf to stop the victimization.
Well, not to get, again, I like to chase rabbits, but this is one where you look at what we did over the last year and a half because of a virus.
Yes.
We shut down schools. We closed down, classrooms. We closed down the economy, made everybody wear a mask. We were just talking about making everybody get vaccinated.
Social distancing.
Stay away. But we can't tell kids that they're not to engage
Right.
in,
it's
challenge
not
them at
healthy.
least not
Right.
to do this, but rather we give them the accoutrements, the equipment to engage in it.
In behavior that is unhealthy, it is
Damaging.
dangerous, it is damaging. They're just, yeah.
So, Meg, this is just one example of other things that are happening in public education. To me, it looks like, and I know this stuff's been going on, so it's not like we're just now discovering it, but it just looked like they've gone crazy.
Well, especially in the area of sex ed and making contraceptives available at school and talking about really beyond the pale topics in sex ed, that's been going on for a number of years.
But it's
And
like it's on steroids.
it's for some reason, and thanks be to God, it's being exposed,
But
right?
could it also be accelerating because they feel like they have the cover of a Biden administration that has made this a top priority?
Well, I don't imagine the Secretary of Education is going to intervene and ask them why they're doing this.
Right.
He's going to say, yes, please, let's have some more. So this is absolutely the case that they all cover each other, right? One thing leads to the next, and they know that they won't be questioned by the media. They won't be questioned by groups on the
Right.
left. They'll be held as being culturally responsive.
So earlier we talked about the role that the state attorney generals are playing in the issue of Title VII and Title IX, but this is something parents have to get involved in.
Yes, parents must get involved. Parents in Chicago should absolutely reject this as an option and demand that it stop. School is compulsory, and the idea that this would be included on the list of things that parents are compelled to tolerate is
But
ridiculous.
don't think it's isolated to Chicago.
No, that's
Every
right.
parent ought to be asking questions. And we've got some resources available for parents to help the
Yes.
probing process to find out what's going on.
Yes, we do. We have a great pamphlet on sex education in public schools that's available on our website. We have, you can send us an email at tipline@frc.org. And if you have something you want to report to us, we get reports about Chicago Public Schools sex ed from time to time. And it's not just, fifth graders, it's bad all the way up.
Okay. All right, Meg, we're going to have to leave it there. We're out of time for today, but